I'm going to run.
I don't even know that I need to go through that part of the analysis because clearly he's demonstrated that he's a flight risk. And so he's not going anywhere today. I hope he enjoyed his little last half hour of freedom.
Good afternoon and welcome back. Today we're diving into a chaotic court session involving Jeffrey Sanders, who is facing charges that we can infer are related to domestic violence, given the Personal Protection Order, or PPO, and the victim's expressed fears. The hearing is finally set for a preliminary examination in what appears to be a Michigan court, but things took a dramatic turn when the prosecution revealed some shocking information about Sanders' actions, leading to a frantic search, a capture, and a very tense return to the courtroom.
Court does call the case of the People versus Jeffrey Sanders.
Good afternoon, Your Honor. Rita Hanna, Assistant Prosecuting Attorney. I'm behalf of the people.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Sanders.
All right. And he's...
So, Your Honor,
go ahead.
Was the date and time set for preliminary examination? Before we even got to that point, there was some conversation I had with defense counsel regarding proceeding with this case, and also information I received that there is a CPS investigation. That investigation is based on the reports that defendant has been living with, or at least at the very least staying with the victim in violation of his PPO as well as violation of his bond conditions.
Hold on a second. The prosecutor isn't just dropping a bombshell. They're laying out a pattern of alleged behavior here. The mention of a CPS investigation, that's Child Protective Services, immediately raises the stakes, suggesting potential child endangerment in the home. This isn't about just an adult victim. Children are possibly involved, making the court's concern for safety even greater. More crucially, Sanders is accused of violating two critical court orders simultaneously: a Personal Protection Order, or PPO, and his bond conditions. In Michigan, a PPO is issued under Michigan Compiled Laws Section 600.2950 and is a civil order designed to protect an individual from domestic violence, sexual assault, or stalking. Violating a PPO is a criminal offense, typically a misdemeanor for a first offense, but subsequent violations can escalate to felonies. The bond conditions governed by Michigan Court Rule 6.106 usually include a no-contact provision, and violating those can lead to immediate bond revocation and further detention. The prosecutor is essentially building a case for why Sanders is a flight risk and a danger, even before they get to the main charges.
I informed counsel of that. I know we had a chambers conference regarding that matter. It was the people's position that we were going to ask for remand to keep him in custody until we could have a bond violation hearing and to adjourn the exam to follow. The victim was not present here this morning, although there was some back and forth about whether or not she was on her way. The victim had expressed great fears about showing up here today and what the defendant would do if he knew that she was going to testify. After our chambers conference, Your Honor, I came out to call the victim. There was some conversation about having the victim appear via Zoom.
This is a critical insight into the victim's perspective and the court's efforts to ensure their safety and testimony. The victim's frank fears about testifying in person are a common challenge in domestic violence cases. Courts often use measures like remote testimony via Zoom or special waiting areas to alleviate this. This aligns with the court's duty to balance a defendant's Sixth Amendment right to confront witnesses with a victim's safety, and courts, guided by rules of procedure and evidence, such as Michigan Court Rule 6.001 and potentially certain rules of evidence for remote testimony, have discretion in these matters. The fact that the court was willing to accommodate Zoom testimony shows that they were taking these fears seriously. But as we're about to see, Sanders' alleged actions only justified those fears further.
So Deputy Raymond Hall and I called the victim to have a conversation with her about the possibility of her doing that. During that conversation, towards the end of the conversation, she caught our attention as we were hanging up the phone and said the defendant had been texting her throughout this whole day, essentially, throughout this whole procedure, and that she wanted someone to go look for him because he had texted her that he was going to run.
This is where the case explodes. The defendant, Jeffrey Sanders, is allegedly texting the victim while in the middle of a court proceeding for a case involving a PPO and bond conditions that almost certainly prohibit contact. This is a clear and egregious violation of a no-contact order, a form of witness tampering or intimidation, which is itself a serious criminal offense under statutes like Michigan Compiled Laws Section 750.122. Furthermore, the victim reports he texted her that he was going to run, which is a direct admission of the intent to flee. This dramatically elevates his flight risk status and would immediately trigger the judge's concern. The prosecutor's immediate action to alert the public defender and have deputies look for Sanders is precisely what is expected in such a high-stakes moment.
I then left the conference room right away. I informed Public Defender Yagi about what we had learned and I was looking for the defendant. My understanding at that point from Ms. Yagi was that the defendant was going to go use the restroom. I came out in the hallway. That is what he claimed he was doing. I had Deputy Raymond Hall follow him based on what we had just learned. Next thing I know, I was back in the courtroom. I heard police stop. And when I went out in the hallway, the defendant was no longer there. And it was my understanding that he had taken off.
In my understanding with reports from security that he took off, it would be the southern emergency entrance out of this building headed in a southerly direction.
And just like that, Jeffrey Sanders confirms everyone's worst fears. He didn't just use the restroom, he fled the courthouse. This isn't just a minor infraction, this is a failure to appear and absconding while on bond. Both serious offenses in Michigan, often leading to new felony charges. The judge now has indisputable evidence of Sanders being a flight risk. A bench warrant is the immediate and appropriate response, typically issued under Michigan Court Rule 6.103. The no bond stipulation is standard when a defendant actively flees, signaling to law enforcement that he is to be held without an opportunity for release once apprehended, due to the high likelihood of him fleeing again.
Yagi, anything?
Your Honor, I don't think there is anything I need to add at this point.
Based upon that, and this is date and time set for preliminary examination, I'm going to issue a bench warrant for the defendant's failure to appear. There will be no bond. That warrant will issue immediately. I have also marked the file that this matter, initially anyway, it might ultimately be set before Judge Washington, but should be set before me when we get him, and we will.
Thank you.
All right. Thank you. And that was going to be a bad conference. Ready? No. Not letting that go. Court does. Can we get Mr. Burke out?
I think he should be in custody.
No, I don't want to go on the record. Yeah, I know.
They found him, Your Honor. So I don't know.
Pardon?
If the court wanted to, I'm sorry, on Mr. Sanders, they found him, but they have him.
They have him?
They have him. Excellent police work. I don't know if the court.
Best in the state.
Do anything today?
Oh, yes. If you guys have time, let's bring him to me.
Your Honor, if I may, I'll go and pick him up right now. He's just around the corner.
Fantastic. I'll be here with bells on. All right, court is standing brief recess.
Well, that was short-lived freedom. The excellent police work means Sanders' attempt to flee was quickly thwarted. The immediate apprehension is crucial for maintaining court integrity and ensuring public safety. The prosecutor's eagerness to have him brought back with bells on highlights the seriousness for which this flight is viewed. Not only has Sanders violated multiple orders, but he's also now directly shown contempt for the court's authority. This incident will undoubtedly have a significant impact on his bond status and overall perception of his character by the court.
You may be seated. Court does call case of the People versus Jeffrey Sanders.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the court.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Sanders, who is to my right.
Jeffrey Sanders. All right.
Your Honor, before we start, I also just received a text message sent from the victim to the officer in charge, Deputy Hall. It's a screenshot at this stage. Of course, we need to get more information. It's a screenshot from someone named Jeffrey saying, you okay? If you want me in jail, just say so. She said, I don't want you to. That was read by him at 11:42 a.m. Then he says 9 out of 10 times I am. Then he says he back. Then he says, can you talk? Then he says, I'm gonna run. This seems to coincide with what the victim was telling us towards the end of our conversation.
All right. So I don't know where you want to start this, Jackie.
I frankly, I don't either. I think what I would request today is that this be set, reset for exam and set for bond violation hearing, because at this point today, I don't feel prepared to go forward on the bond violation aspect.
Here, the public defender, Ms. Yagi, is navigating an incredibly difficult situation. Her client just publicly demonstrated contempt for court and likely jeopardized his entire case. Her request to reset for exam and set for bond violation hearing indicates a need for time to regroup and properly prepare. Under the Sixth Amendment, a defendant has the right to effective assistance of counsel, which includes adequate time to prepare. While the bond violation is clear, she's acknowledging she needs to discuss the allegations with her client thoroughly. This is a procedural move to protect Sanders' rights, even though his actions have made her job exponentially harder. She also strategically mentions needing context for the texts, attempting to mitigate the bond violation's impact on sentencing, a common defense tactic even in the face of clear violations.
To be candid with the court, I just need more time to talk to Mr. Sanders about these allegations that I just learned about a few hours ago, and I need to go through them in more depth and more detail with Mr. Sanders.
Okay, but just so that we're clear, as we were going through the conversation this morning regarding certain reports and certain other things and certain allegations by the alleged victim in this case, in a lot of ways is referencing his status right now. Aren't those irrelevant to the court? I mean, because, well, I won't say absolutely irrelevant, but for the purposes of today, certainly they're no longer relevant. I mean, even if, which was the court's attempt to try to determine as to whether or not he might pose some threat to, I don't even know that I need to go through that part of the analysis, because clearly he's demonstrated that he's a flight risk. And so he's not going anywhere today. I hope he enjoyed his little last half hour of freedom. Anywhere today. I hope he enjoyed his little last half hour of freedom. And so, I mean, there's that issue. And also, we were getting indications, and they will get them, that he was texting the victim, and he's got a no contact.
The judge is clearly exasperated and is not mincing words. His statement, "I hope he enjoyed his little last half hour of freedom," is a judicial smackdown. He's making it crystal clear that Sanders' flight has solidified his status as a flight risk. Under Michigan Court Rule 6.106b, factors for setting bond including the defendant's prior record, character, and risk of flight. Sanders has now demonstrated a flagrant disregard for court orders and a high propensity to flee, making his pretrial release highly unlikely. The judge is also confirming the severity of the no-contact order violation, emphasizing that this isn't a trivial matter.
I understand.
I mean, I'll set it for a hearing, but I don't know.
I think one of my questions, well, the first question would be, obviously, is there a bond violation? The next question is what is the appropriate sentence for that bond violation? One of the things that I do think is especially relevant is, I do think it would be relevant for the court's consideration in terms of a sentence for a bond violation, the context of the conversations. And I don't have that at this time. And I think it would be important for me to be able to prepare and for the court to have, because I mean, I don't want to necessarily go further today, but I think it does make a difference if there is contact with someone, versus if someone is calling, texting, and saying, will you respond? And then there's a response. I just think it matters in terms of sentence, even if it doesn't matter in terms of whether or not there's a violation, because one of the things that the state's witness said this morning was that she had been reaching out and asking for a response.
Your Honor, first of all, I'm sorry, may I?
Yes.
First of all, I don't appreciate that my conversation that I had with a victim in this case was overheard, listened to, whatever it may be. The part that's now being put on the record is also a great deal about why that victim did not show up today. And as we witnessed, quite frankly, she probably had good reason not to show today, because I don't know what defendant would have done. And I had to call this victim. I had to have deputies go out and have our victim advocate contact her and essentially tell her, take your kids and run, get out of the house, because that's very likely where he was going. After finding out that she was going to appear on Zoom. I mean, she was willing to appear on Zoom and testify today, despite all her hesitations. And he decides to run, and he's messaging. I cannot imagine a context where that is okay or acceptable or excusable in any way. We're here for a court hearing, and he is messaging her as we're talking to her. So I want to be very clear. I don't think it's appropriate to further put any statements the victim made on the record in front of this defendant, because quite frankly, we're just increasing her risk here. This is high lethality, 100%.
The prosecutor's passionate intervention here is crucial. They are highlighting the extreme danger posed by Sanders' actions, going beyond just a bond violation to discuss the victim's immediate safety. The phrase high lethality 100% is a stark warning, often used in domestic violence assessments to indicate a very high risk of the abuser killing the victim. This is not hyperbole. It's a professional assessment based on the defendant's alleged pattern of control, intimidation, and direct violation of protection orders. The prosecutor's objection to discussing further victim statements in open court in front of the defendant is a protective measure based on victim safety protocols and the Michigan rules of evidence, particularly around victim impact or sensitive testimony. She's prioritizing the victim's life over the defense's request for context that could inadvertently be used to further endanger her.
And we're not going to contribute to making the risk for her even greater than it is by talking about statements she made in confidence speaking to me. We're just not going to do that. So I would ask Ms. Yagi to stop right there if she's going to get into further anything that has to do with what the statements the victim made.
I understand. I will request that it be set for bond violation hearing. I don't feel prepared today to address it. I think there are statements that are discoverable, and so I'll follow up with the prosecutor about that.
Can efforts be made to have the victim available next week?
We'll do our best, Your Honor.
All right. So what I'm going to do is I'm going to, first of all, adjourn the preliminary examination. I'm going to keep the case. It would go back to Judge Washington on the 28th, but we'll get it heard sooner if I keep it. So I'll set the preliminary examination for October 21st, 2025, 9 a.m. That will be before me.
The judge's decision to adjourn the preliminary examination and keep the case before himself rather than letting it revert to Judge Washington indicates his intent to maintain control over this volatile situation. This is a tactical judicial move, demonstrating the judge's recognition of the immediate danger and the need for a firm hand. The preliminary examination, governed by Michigan Compiled Laws Section 766.1, is where a judge determines if there's probable cause to believe a felony was committed and the defendant committed it, binding the case over to circuit court. By keeping it and scheduling a bond violation hearing concurrently, the judge is streamlining the process, ensuring all related issues are addressed efficiently under his oversight. This also ensures continuity, as he has firsthand knowledge of the defendant's flight and the victim's expressed fears.
I'll also set a bond hearing. We'll hear it sometime that day. Bond violation hearing. Anything you want to say before I do what I'm going to do regarding bond?
Not from me, Your Honor.
You know, Mr. Sanders, I'm just going to say this before I do it because I think it's important. Your attorney was back there, her and the prosecutor, going back and forth, and I'm sitting there listening. And I tried my best to make sure that every opportunity was at least afforded before any presumption was made regarding any contact, regarding any of that. by having the victim appear via Zoom.
You've witnessed a truly wild moment in court, illustrating the immediate and severe consequences when a defendant flagrantly disrespects court orders and tries to flee. While we thoroughly search for the final outcome for the People versus Jeffrey Sanders case with prosecutor Ray Tran and public defender Laura Yagi, a definitive public record detailing the verdict or sentencing for this specific incident is not readily available through general searches. This is often the case with district court proceedings, particularly for bond violation hearings or preliminary examinations, which may not always generate high-profile news or appear in accessible appellate court databases. However, based on the events in the transcript, we can expect the bond violation hearing and preliminary examination would have proceeded on or after October 21st, 2025. Jeffrey Sanders would almost certainly have faced severe repercussions for his actions, including the revocation of his bond and potentially new criminal charges for absconding and witness tampering. His flight would significantly damage his credibility and make any future attempts at pretrial release highly unlikely. The court's focus on victim safety and holding defendants accountable for their actions was clearly paramount here. What do you think about the judge's swift actions? Let us know in the comments below, and don't forget to like and subscribe for more courtroom drama.